Hello friends, welcome to Abhinav Goswami Law classes. So friends, in this video we are going to discuss from section 34 to section 38 of Indian Evidence Act. Why I am doing these five sections together? Because they form part of a same chapter which provides for statements which are made under special circumstances. So they are interrelated. That is why I am going to do them together and I will try my best to conclude this lecture within 30 minutes. So friends, please open your BRX, open section 34. Okay friends. So section 34 says entries in books of account when relevant. Okay. So what are we talking about? Entries in books of account. Entries in books of account, including those maintained in an electronic form, regularly kept in the course of business, are relevant whenever they refer to a matter into which the court has to inquire. But such statements shall not alone be sufficient evidence to charge any person with liability. Very important, very easy. So section 34, keep this in mind. Okay, keep demarcating the section. So section 34, the first section, deals with entries in books of account. Okay, this is the first thing that you need to keep in mind. The first point about section 34 is that it deals with entries in books of account. The second important thing about section 34 is that this term books of account includes within itself electronic records also. Okay, so electronic records which are maintained in a particular system, in a particular laptop or a computer, that may also fall within the definition of books of account. So books of account not necessarily has to be a physical copy. Okay, this is the second thing that you learn about it. The third point that you need to learn about is this book of account, this entry, this book of account on which you are relying must be kept in the ordinary course of business, must be regularly kept in the course of business. So it must be a part of the business to maintain such books of account. It should not be any special book or it should not be any special circumstance. It must be a book dealing with general matters which are generally maintained in a particular course of business, right? So kept in the course of business. This is, friends, one of the most important requirement of this, that the diary or the book of account or whatever electronic record you are relying on, that has to be maintained as part of the course of business. Okay friends, the fourth requirement are that once these three requirements are satisfied, then the court may rely on entries of such book as a relevant fact. Okay, this is the fourth consequence. But the final consequence of section 34 is that though the court may rely on entries in these books as relevant facts, but again these entries cannot be the sole basis for any prosecution or any liability. They are relevant, they may help to prove or disprove a particular thing, but on their own basis they cannot be the basis of any liability or any prosecution. This is very important, you need to keep in mind. You need certain independent evidences also along with these entries if you want to make any particular person liable or prosecute any person on the basis of that. In itself these entries will never be sufficient. So friends, we are going to repeat it quickly. What are the 5 points that we learn about section 34 is that it talks about entries in books of account. Okay. Second point was this term books of account includes electronic records. Third important thing is this books of account or electronic record, they must be maintained in the ordinary course of business. And finally, the fourth requirement is that if all these three requirements are satisfied, then the court may rely on entries in such books as relevant facts. But most importantly, these entries cannot be the sole basis of the liability of any particular person. We need independent evidences. So 5 points. Okay. Now come to illustration. A sues B for rupees 1000 and shows entries in his account books showing B to be indebted to B to this amount. The entries are relevant but are not sufficient without other evidence to prove the debt. So with the in the circumstance of this illustration, we will try to apply the 5 conditions that we have just learned. So what is happening in this case, friends? A is suing B for rupees 1000. Okay, that is the factin issue. That is a separate thing. Now, what he is relying on to prove the liability of B, he is saying that he is showing a entry in a book which he maintains. Okay, so what are the things that we will look at, friends? That this book is ordinarily maintained in the course of business. If this book is ordinarily maintained in the course of business, then the court can rely on this. So this entry which the person A is trying to show, it mentions that B actually owes 1000 rupees to A, right? This book is showing that. So this entry is a relevant fact showing the liability of B for 1000 rupees. But again, the fifth point, that this entry in itself is not sufficient to prove the liability of B. We need some other evidences also. Okay, friends. Now come to section 35. Relevancy of entry in public record made in performance of duty. So friends, as far as section 35 is concerned, you need to keep in mind that it is talking of public record. But when we were talking of section 34, we were talking of books of account. So these books of account can be maintained by any private person in the ordinary course of business. So this term books of account is quite broad. It can be maintained by any particular individual, any businessman, any public officer also. So there are no limitations. But as far as section 35 is concerned, it specifically mentions about public record, and those public record which are maintained by people in performance of their duty. So this maintaining of public record must be part of their duty, part of their job. Only then entries in this public record will become relevant under section 35. So with this, let's start with section 35. An entry in any public or other official record, official book, register or record, or an electronic record, stating a fact in issue or relevant fact and made by a public servant in discharge of his official duty or by any other person in performance of a duty specifically enjoined by the law of the country in which such book, register or record or an electronic record is kept, is itself a relevant fact. So friend, as far as section 35 is concerned, what are the things that we need to keep in mind? The first important requirement for the application of section 35 is that it has to be an electronic record. It has to be a public record. Okay, public record or any other official record. So why this terminology is used, that any public or other official book? So in a particular circumstances, in a particular organizations, it may happen that a dispute may arise whether this organization who is maintaining this book is a public authority or not. So this is a big issue. So for removing all those doubts from the mind of the court, it has been provided that it includes public and other official records. Okay, so even though the authority may not be strictly falling within the definition of public authority, but the document which is maintained by such authority is an official document that may be relied upon. So the first thing that we need to learn about section 35 is that it must be a public or other official book register. So we are going to refer it as record, which includes electronic record. Okay, this is the first part. What are the things? That it has to be public or official record, including electronic record. Okay, second important thing is that the entry on which we are relying must be stating either a fact in issue or a relevant fact. So we have already covered, friends, from section 6 to 16, which explains what are the relevant facts. And when we did the definitions, I explained to you what is fact in issue. Fact in issue are those facts which are the essential basis, the main dispute between the parties, and relevant facts are those facts which either help or go against this fact in issue. So this entry in the public record or other official record must be stating a particular fact in issue or relevant fact. This is the second requirement. Third important requirement is that this is one of the most interesting and important requirement, that this entry in this public record or official record must be made by a public officer or a public servant in discharge of his official duty. This is the most important requirement, that this public and this entry on which the court wants to rely must be made by a person in discharge of his official duty, or if even if the person who made the entry is not falling within the definition of public servant, because the term public servant is very restrictive. Then if the entry was made by such a person who was exercising the duties which are imposed on him by any particular law. So why this again, these two types of things are provided, that a public servant in discharge of his official duty or by any other person in performance of a duty specifically enjoined by the law, just to enlarge the scope of section 35, because the court is so that the court is not bound to go into details whether a particular person is strictly falling within the definition of public servant or not required. Even if that particular person who has made the entry is not falling within the definition of public servant, even then that entry can be relied on if the entry was made in pursuance of any law. Okay, so what are the four requirements, friends? Again, quick recap, that it is a public record. First, most important requirement, it is stating a fact in issue or relevant fact. Third, this entry was made by a public servant in discharge of his official duty or by any other person who on the basis in the pursuance of any particular law which is applied on him. Once these three requirements are satisfied, then this entry can be relied on by a court of law as a relevant fact. Okay, friends, as a relevant fact. So, friends, try to make a distinction between section 34 and section 35. Section 34 specifically mentioned that even if all the requirements of section 34 are satisfied, that entry in itself cannot be the basis of liability, right? But when we came to section 35, we do not find mention of any such rule, which means that the court may make the basis or make this entry in a public record the only basis for the liability of any particular person. Okay, so of entry in public records can become the basis of sole basis of liability, which is not the case with section 34. Okay, friends, with this we will move forward to section 36, relevancy of statements in maps, charts or plans. Okay, statements of fact in issue or relevant fact made in published, very important, published maps or charts generally offered for public sale, or in maps or plans made under the authority of the central government or any state government, as to matters usually represented or stated in such maps, charts or plans, are themselves relevant facts. So friends, the first thing that you need to learn about section 36 is that it is talking about the facts which are provided in any particular map, in any particular chart or in any particular plan. Okay, so it is talking about three category of documents: maps, charts and plans. Okay, but what are the requirements of application of section 36? The first important requirement is that the statement which we want to make relevant, the statement which is mentioned in this map, chart or plan, this statement has to be either fact in issue or in relation to relevant fact. So the same requirement that was there in section 35, that the statement has to be either referring to fact in issue or relevant fact. This is the first and the most important requirement. Second most important requirement, that it is not all maps, all charts or plans that which can be prepared by any person with no authority. No, all those maps, charts and plans are not what section 36 is referring to. Section 36 is talking of only published, the term please underline this term, published maps, charts and plans which are generally offered for public sale. Okay, so section 36 can be applied only on those statements which are mentioned in published maps or charts which are generally offered for public sale. This is the first category of documents on which this can be relied on, or in maps or plans made under the authority of the central government or state government, or if that those map charts are not published, or if they are not offered for public sale, then if those maps or plans are published are made under the authority of the central or state government, even though they are not published, even though they are not available for public sale, then also these documents can be relied on if they are made under the authority of central or state government. Okay, so two categories of map, charts and plans can be relied on. Entries in two categories of these documents can be relied on. Either these documents, map, charts and plans, have to be published and generally available for public sale, or they must be made with the authority of the central or state government. If any of these two requirements are satisfied, then any of the statements that are made in such maps, charts and plans, they can be relied on by the court of law as relevant facts. Okay friends, so there were three requirements under section 36. What were those requirements? The first requirement was the statement on which we want to rely on must be a relevant fact, or must be related to a fact in issue or relevant fact. First requirement. Second requirement, that such maps, chart or plan should be either published and available for general public, or must be made with the authority of central or state government. Okay, and finally, once these two requirements are satisfied, then the court can rely on such statements as relevant facts. So again, the prohibition that was there in the section 34, that these statements cannot be the sole basis of liability, is not mentioned under section 36. So they can become the basis of liability, of a sole basis of liability of any particular person. Now come to section 37, relevancy of a statement as to fact of public nature contained in certain acts or notifications. So very important. What we are going to focus on section 37, we are going to focus on certain acts which we read are statutes and other notifications which are of friends public nature. When the court has to form an opinion as to the existence of any fact of a public nature, any statement of it made in a recital contained in any act of parliament of the United Kingdom, or in any central act, provisional act or state act, or in a government notification by the crown representative appearing in the official gazette, or in any printed paper purporting to be London Gazette or the government gazette of any dominion, colony, possession of His Majesty, is a relevant fact. Okay friends, so as far as section 37 is concerned, don't be confused by the size of name. What are the things that are mentioned? In simple words, section 37 is simply requires two important things. What is the first important thing? That the statement which a particular court want to rely on, has to be of a public nature. Very important. So if the statement on which the court wants to rely is of a private nature or is relating to any particular stance, no, that cannot be relied on. The statement has to be of a public nature. Second important requirement is that statement of public nature can be based in or can be mentioned in any act of parliament of UK or other central or provisional act, or any state or government notification, or under crown representative acts. So all these acts, all these categories of authorities that are mentioned, if such a statement of public nature is mentioned in any such a statute or any such notification, then it can be relied on by the court of law as a relevant fact. So friends, this section 37 has not been amended properly. All these authorities must be referring to Government of India and state governments. Okay, so we will automatically try to imply it in such a manner. But as far as the rule of evidence is concerned, we need to remember two important facts: that the fact on which the statement on which the court wants to rely has to be of a public nature, and it has to be mentioned in a central or state statute or notification. Very simple. Now come to our final section for today: relevancy of statements as to any law contained in law books. Okay, very interesting. Law books that we read, right? So when the court has to form an opinion as to a law of any country, very important, any statement of such law contained in a book purporting to be printed, very important, printed or published under the authority of the government of such country, or to contain any such law and any report of a ruling of the courts of such country contained in a book purporting to be a report of such ruling is relevant. Okay, friends. So if the court has a confusion regarding law of a particular country, okay, particular foreign country, we are not sure what is the law of that country which we need to apply in this case. Okay, so if such a question arises, where would the court go? So what the court can do, the court can look for books which were either printed or published with the authority of the government. So if these two requirements are satisfied, that first requirement is that the Indian courts, our courts, has to form opinion as to foreign law. Okay, this is the first requirement. Then the book they can rely on to know that foreign law has to be either printed, or if not printed, then published with the authority of that country on whose law we want to know about. Okay, this is the second most important requirement. And same goes with the rulings of the court. These rulings we want, because the law, we can become aware of law from rulings also. These rulings also, if we want to rely on that, they must also be either printed or published with the authority of law, and they must be such which will be which has the authenticity of being a representative copy of the judgments of that country. Okay, don't get confused. Simply two things that you need to remember as far as section 38 is concerned: that the court has to know about law of a foreign country, and then it can rely on those books which are either printed or published, or case rulings which were either printed or published with the authority of the government of such country. Okay, once these two requirements are satisfied, these statements of mentioned in those books or in this case laws become relevant facts. Okay, friends. So this was our discussion for today. We will do a quick recap. Section 34 talked about normal books of account. Okay, normal books of account which any particular private person can maintain from day to day. Okay, section 35 talked about public records, and one additional requirement that they have to be mentioned as part of their performance of a public duty. Okay, section 36 talks about maps, charts, and plans. Okay, section 37 talked about statutes and notifications, and finally section 38 talks about law books and case laws. Okay, friends, with this I hope you understood these laws that we discussed today from section 34 to 38. They become quite important when you practice in a court of law, or for your exams also, from objective type questions and subjective type questions also. So you need to keep these sections are very easy. They are not very hard. Very easy section. Just keep the requirements in mind that I have just mentioned. Okay, friends. With this, I will close this video. I hope you enjoyed this lecture. So friends, if you want to appreciate my efforts, please subscribe to my YouTube channel and connect with me on Telegram. The invitation link to my Telegram group is in description to the video. Until then, friends, be safe, be happy. I'll see you very soon. Bye-bye.